Let's talk about something that most of us in the US just assume we have, the right to privacy. You know, the idea that there's a part of our lives that's just ours, away from prying eyes. But where does that right actually come from? The answer might surprise you. Okay, let's just dive right in with a pop quiz. Think about the US Constitution, the Bill of Rights, all those big, important documents. Where in there specifically are the words right to privacy? Take a second. Can you picture the amendment? If you're coming up empty, well, there's a very good reason for that. That phrase, right to privacy, is nowhere to be found in the Constitution. Not once. It just isn't there. And that's the mystery we're going to unpack. So, what gives? If our most fundamental legal text doesn't even mention privacy, how did it become such a huge part of our legal world? This is the story of a right that's unwritten, but, as you'll see, incredibly powerful. Here's probably the best way to think about it. Imagine your life is a house. You've got locks on the doors, you've got curtains on the windows. It's not because you have something to hide, it's because you believe you should be the one to decide who gets to come in and who gets to look inside. Well, the right to privacy is basically the legal version of those locks and curtains. It's about control. So how in the world did we get a right that isn't actually written down? Well, it's kind of a legal detective story. The courts had to find it by looking in the shadows and between the lines of the rights that are explicitly mentioned. This whole idea didn't just appear out of thin air. The seeds were planted way back in 1791 with the Fourth Amendment, which protected our physical stuff, our houses, papers, and effects. Then, almost a century later, in 1890, two lawyers, Warren and Brandeis, saw this newfangled technology called the camera and got worried. They wrote a famous article arguing for a right to be let alone. And that idea just simmered for decades until, boom, 1965, when the Supreme Court finally made it official in a landmark case called Griswold v. Kenned. To justify this, the court used a really fascinating word, penumbra. It's a fancy term, but the idea is simple. It refers to the rights that aren't spelled out, but exist in the shadows cast by the rights that are spelled out. It's like the First, Third, Fourth, and Fifth Amendments all create this big zone of personal freedom, and lurking in those shadows is the right to privacy. Okay, so having a right to privacy sounds great and all, but what does it actually do? What does it protect in the real world? Well, the courts have generally broken it down into four main zones. We're going to walk through these four really quick. It's about your space, your big life decisions, your personal information, and even your own identity. Let's start with the one you probably know best. Zone 1 is the classic. This is the one everybody thinks of, and it comes straight out of the Fourth Amendment. This is the get a warrant zone. It protects your home, your body, your belongings from the government just barging in without a good reason. Now, Zone 2. This is where things get way more expansive and, frankly, a lot more controversial. This is about personal autonomy. It's your right to make fundamental, life-defining decisions. Think marriage, raising your kids, things like that, without the government telling you what to do. This zone protects the choices that really make you, you. And that brings us to a zone that is a massive, massive battleground today, your personal information. This is about your right to have some say over who's collecting your data and what they're doing with it. We're talking about everything from your private medical records to that giant digital footprint you're leaving online every single second. And finally, Zone 4, which is a little different. This one isn't so much about the government. It's about protecting the commercial value of who you are. It basically means a company can't just slap your face on a t-shirt or use your name in an ad campaign without your permission. It stops others from cashing in on your identity. Now here is the crucial thing to remember. Because this right is unwritten, it is not set in stone, not at all. It is constantly being challenged, argued over, and totally redefined by the courts, especially as technology just keeps leaping forward. And you just can't talk about this without looking at the debate over abortion. In 1973, in Roe v. Wade, the Supreme Court decided that the zone of personal autonomy, that Zone 2 we just talked about, was broad enough to cover a woman's decision to have an abortion. For almost 50 years, that was the law. But then, in 2022, the court's decision in Dobbs completely overturned that, finding that the Constitution does not grant that right. It's a huge example of how this implied right can be dramatically reinterpreted. But while some protections have been narrowed, others have actually expanded to deal with new threats. Take the Carpenter case from 2018. This was all about our digital lives. The Supreme Court,
led by Chief Justice Roberts, said that the government generally needs a warrant to get your cell phone location history from your provider. This was a really big win for digital privacy, applying those old Fourth Amendment ideas to our 21st century lives. And this is so critical to understand. Your privacy rights can change, sometimes dramatically, just by crossing a state line. The federal right is like a baseline, a minimum level of protection, but states can add more. For instance, California put a right to privacy right into its state constitution, and it applies to private companies, not just the government. But then you look at a place like New York, and the right is much narrower, only covering what's been written into specific laws. It's a real patchwork, and it means where you live really matters. So where are we headed? What's the next frontier? The big privacy fights of the future probably won't be about cameras in a public square. They're going to be fought over technologies that we're all just starting to grapple with. You've got these three huge areas that are just exploding. First, artificial intelligence, AI, and its scary good ability to build these incredibly detailed profiles about every single one of us. Then there's biometric data, things like facial recognition, which turns your face into a data point that can be tracked anywhere. And maybe the most personal of all, your DNA. Who owns your genetic code after you spit in that tube? The law is running to try and keep up. And all of this leaves us with one final, really important question. This unwritten right started with a simple idea, the right to be let alone. But now, as technology can know almost everything about us, who gets to write the rules? Who decides where the line is? Is it the courts, Congress, the tech companies? Or is it up to us, all of us, to start demanding the kind of privacy we want to live with? That's the question we're all going to be answering for a long time to come.